Hey, this is Angela, and you're listening to the Study for the Bar in Your Car podcast. Anyhow, it has been a long day. So for me, today's Saturday, and I spent the day in my bar study class. So I'm taking a class specifically for MEEs, the essay part of the bar, which I can't seem to crack. I'm one of those people that get really nervous when doing MEEs, and I had a little bit of a breakthrough. I don't know if this is a great breakthrough, but I figured out like part of my issue with doing essay questions for the bar is really going from one idea to the next. So when I have the rule, like having the rule, and then I, go back and find the text that the rule applies to, but it's like the words to link one idea to the next idea. And it really hurts my ego because I always felt that I was a strong writer, but apparently I'm not a strong essay writer, but I guess I'm strong in other things. Anyhow, so not to delay this further, this is the podcast where you can study for the bar in your car. Now, you won't be learning from me because I'm just a law student like you. I am still trying to get through all of this. But I do have these two AI pals. I've put all my notes that I've taken and my outlines into AI, and I've generated a podcast. So you'll be listening to a podcast within a podcast. And these two AI bots, I call them Maud and Claude, they have really cracked this thing. So it's a really interesting conversation, and I feel like a new way to study. And hey, for me, this is all one big experiment. So I'm not a lawyer. I'm not giving legal advice. AI isn't always correct. If I hear anything that's incorrect, I usually take it out or redo the podcast. Anyhow, if you need to get in touch with me, you can reach me at podcast@studyforthebar in your car. Now here are two hosts, Maud and Claude. Take it away, guys.
Welcome back to the Deep Dive. Today, we're really getting into the weeds of federal civil procedure.
That's right. We're looking at some key moments in a lawsuit, pretrial motions, those crucial judgment calls during trial, and what happens even after a verdict.
And we're using Angela's Study for the Bar in Your Car notes as our guide. Think of this as decoding the strategic moves lawyers make.
Exactly. So whether you're maybe prepping for class, trying to follow a case, or just curious about how it all works.
Our mission here is to give you a solid, practical handle on these motions without, drowning you in legalese.
Let's do it. These motions really shape how a case unfolds.
Okay, so let's kick things off with pretrial motions. Angela's notes mention motions addressed to the face of pleadings. What are we talking about there, basically?
Right, so these are the very first challenges. They attack the lawsuit's foundational documents, usually the complaint, sometimes the answer.
It's like saying, hold on, there's a problem with the paperwork itself.
Precisely. A fundamental flaw that maybe means the case shouldn't even proceed.
And a key player here, according to Angela's outline, is the motion to dismiss. That's Rule 12.
Ah, yes, Rule 12. It's a defendant's tool to try and end the case early before digging into evidence.
For what kinds of reasons?
Well, Angela lists several. Big ones are lack of subject matter jurisdiction. The court can't even hear this type of case, or lack of personal jurisdiction.
Personal jurisdiction meaning the court doesn't have power over that specific defendant.
Exactly. And Angela's bar prep stuff even notes that sometimes just being physically present in the state when served can be enough, surprisingly, unless it was tricky, like fraud, to get you there.
Wow. It really shows how vital getting the procedure right is.
Oh, absolutely. And Angela emphasizes this. A judgment is void, totally invalid if service wasn't done properly.
Even if the defendant actually knew about the lawsuit.
Even then, it's about that formal notice, the due process. You have to be properly brought into the court's power.
And the timing for responding is tight. Angela notes 21 days normally.
Right, after formal service. But it gets longer, 60 or even 90 days if the defendant agrees to waive formal service. Saves time and hassle sometimes.
But there's also a limit for the plaintiff to actually serve the complaint, right? 90 days after filing.
No, 90 days. Though Angela points out the court can grant extensions if there's a good reason. But, not just because the lawyer dropped the ball. Attorney negligence usually isn't good cause.
Okay. What else can a Rule 12 motion argue?
Well, improper venue, wrong courthouse, essentially. Or the big one, failure to state a claim.
Meaning Even if everything the plaintiff says is true, there's no actual legal case there.
Exactly. Like the law just doesn't recognize that kind of claim based on those facts. And Angela also touches on motions to strike, getting rid of, say, insufficient defenses or totally irrelevant stuff in the pleadings. Keep it focused.
Got it. So those are the early challenges. Then Angela mentions the motion for judgment on the pleadings. How's that different?
Good question. Timing is key. As Angela explains, this one, Rule 12C, comes after the pleadings are closed. So, complaint, answer, maybe a reply to a counterclaim, all that's done.
So it's based on the complete set of initial documents.
Right. You're saying, look, just based on what we've all formally filed, it's clear I should win. No outside evidence allowed at this stage, just the pleadings. A motion to dismiss usually happens before the answer is even filed.
Okay, that makes sense.
Yeah.
Now let's move to summary judgment. Rule 56. This sounds like a really big hurdle.
It absolutely is. Summary judgment is huge. Angela's outline nails the standard. It's granted if there's no genuine dispute as to any material fact, and the moving party deserves judgment legally.
No genuine dispute of material fact. Let's unpack that based on Angela's materials. What does genuine dispute mean here?
Angela clarifies, it means there's enough evidence on both sides of a factual question that a reasonable jury could actually find for the party opposing the motion. It's not about who the judge believes more.
So the judge isn't weighing credibility at this point.
No, not supposed to. They have to view all the evidence and draw all reasonable inferences in the light most favorable to the party opposing the motion.
And material fact. That means a fact that could actually change the outcome of the case.
Precisely. If the disputed fact wouldn't matter to the legal result, then it's not material and the dispute doesn't block summary judgment.
So if there's a real disagreement about a crucial fact, summary judgment is generally off the table.
That's the idea. And as Angela really stresses, the side opposing summary judgment can't just sit back. They have to actively point to specific evidence.
Like what kind of evidence?
Things like affidavits, sworn statements, deposition transcripts, documents, interrogatory answers. They have to show the court, look, here's proof there's a real fight about the facts. You can't just rest on what you said in your complaint.
And Angela notes those affidavits have to be based on personal knowledge, right? Not just speculation.
Absolutely. Personal knowledge and facts that would actually be admissible if you went to trial. No hearsay or, wild guesses.
Makes sense. You need solid ground. Angela also mentions summary judgment can be partial.
Yeah, the court can grant it on just one claim, or even just the issue of liability, leaving damages for trial, for instance, resolving what it can.
And if a judge denies summary judgment, that decision usually can't be appealed right away.
Generally, no. It's not a final order ending the case. But, Angela notes, if summary judgment is granted partially or fully, that is a final decision on those issues and can be appealed once the whole case reaches a final judgment.
Okay, so it's a major dispositive motion, as they say. It can dispose of the case or parts of it.
Definitely. A huge tool in the litigation toolbox.
All right, let's say the case survives those pretrial hurdles and actually goes to trial. Now we get into motions for judgments as a matter of law. Angela notes this used to be called a directed verdict.
That's right. Older term was directed verdict. Now it's JMOL under Rule 50A.
And when does this happen?
Angela's notes explain you make this motion after your opponent has fully presented their evidence on an issue, but before the case goes to the jury.
And the argument is?
Essentially, Your Honor, even looking at all the evidence they just presented in the best possible light, no reasonable juror could possibly find for them on this claim. There's just not enough evidence legally.
So the standard sounds similar to summary judgment, but now it's based on the trial evidence.
Very similar standard, yes. Legally sufficient evidentiary basis. And again, Angela highlights the court must view the evidence most favorably to the non-moving party, draw all reasonable inferences their way, and even generally assume their witnesses are credible for purposes of this motion.
Okay. Angela really flagged something important here. You have to make this motion at the close of all evidence if you want to preserve the possibility of making it again later.
Crucial point, yes. Under Rule 50, you generally must move for JML before the case is submitted to the jury to be able to renew it after the verdict. It's a prerequisite.
Okay, so that leads us directly to the renewed motion for judgment as a matter of law, RJOL. Angela says this used to be JNOV judgment notwithstanding the verdict.
Exactly. JNOV is the old name. RJMOL, under Rule 50B, happens after the jury has returned its verdict.
And the standard is the same as the JMOL made during trial.
Yes, essentially the same high bar. Angela's notes are clear. You're arguing that the jury's verdict isn't supported by substantial evidence, that no reasonable jury could have reached that conclusion based on the trial evidence.
But the absolute key, as Angela underscores, is you could only make this RJML if you made the initial JML motion earlier.
That is the critical procedural lock. If you didn't move for JML at the close of evidence, you've generally waived your right to file an RJML after the verdict. You can't surprise the court or the other side with it after the jury has spoken if you didn't raise the sufficiency issue before deliberations.
So you give the judge a chance to rule before it even gets to the jury. If they deny it then, and the jury finds against you, you can then ask the judge to reconsider via RJML.
That's the pathway. It preserves the issue.
Okay, makes sense. Now, we've gotten through trial, maybe there's a verdict. What about post-trial motions? Angela covers these last.
Right. These are ways to challenge the judgment after it's been officially entered. Angela's notes focus mainly on two: motion for a new trial, Rule 59, and motion for relief from judgment, Rule 60.
Let's take the motion for a new trial first. Angela suggests the reasons for this are broader than for RJML.
They are definitely broader. Rule 59 allows a new trial for various reasons. Angela outlines things like significant legal errors during the trial that were prejudicial.
Like maybe the judge admitted evidence they shouldn't have.
Exactly. Or gave the jury the wrong instructions. Also, newly discovered evidence if it was truly unavailable before despite diligent effort.
What else?
Prejudicial misconduct by a lawyer, a party, even a juror. And a big one, Angela notes, if the judge concludes the verdict is against the great weight of the evidence.
Wait, how is that different from the RJML standard?
It's a less demanding standard. For RJML, there has to be no legally sufficient evidence. For a new trial based on weight of evidence, there might be some evidence, but the judge is essentially saying, I've heard everything, and I'm firmly convinced the jury just got this wrong, either on who wins or how much.
So the judge can disagree with the jury more easily here than with an RJML.
In a sense, yes, they are weighing the evidence more directly. And Angela points out this motion is often filed together with an RJML as an alternative. Importantly, you can move for a new trial even if you didn't make a prior JML motion, unlike the RJML.
Ah, okay. And the judge can even order a new trial on their own.
Yes, Angela mentions the court can do that sua sponte on its own initiative within 28 days after judgment.
Got it. What about the other one? Motion for relief from judgment under Rule 60. Angela's notes say this is for, more fundamental problems.
That's a good way to put it. Rule 60 is about setting aside a final judgment in more limited, often extraordinary circumstances. Angela breaks it down. Rule 60A is just for clerical mistakes.
Typos, calculation errors, that sort of thing.
Exactly. Oversights, omissions, those can be corrected pretty much any time, though appellate court permission might be needed if an appeal is already filed.
Okay, simple enough. What about Rule 60B? That sounds more serious.
It is. Angela lists several grounds here, and the timing is critical. Within 1 year of the judgment, you can seek relief for mistake, inadvertence, surprise, or excusable neglect.
Excusable neglect. Seems a bit vague.
It is. Depends heavily on the facts. Also within that 1 year, newly discovered evidence that couldn't have been found in time for a Rule 59 new trial motion, and fraud or misconduct by the opposing party.
Okay, 1 year deadline for those. What if the problem is even more fundamental, like the judgment being void?
Right, like if the court never had jurisdiction to begin with. For void judgments, Angela notes the motion must be made within a reasonable time, which could be longer than a year.
What else falls under reasonable time?
Situations where the judgment has been satisfied or discharged, or it's based on an earlier judgment that got reversed, or it's just no longer equitable for the judgment to apply going forward. And there's a catch-all, Rule 60b-6, for any other reason that justifies relief, but Angela notes that's very hard to get granted, reserved for truly exceptional circumstances.
And timing, again, seems paramount for all these post-trial motions.
Absolutely critical. Angela hammers this home. For RJMOL under Rule 50B and motions for a new trial under Rule 59, there's a strict 28-day deadline after the judgment is entered.
28 days, that's it. No extensions.
No extensions allowed for those two. You miss it, you lose the chance. Rule 60 motions have their own timing, the 1 year or reasonable time limits we just talked about.
Wow. Okay, so bringing this all together from Angela's notes, we've seen how you can challenge the case right at the start with pleadings motions, then test the facts before trial with summary judgment.
Then challenge the sufficiency of the evidence during trial with JMOL, and then after the verdict with RJMOL, or a motion for a new trial, or even later seek relief under Rule 60 for specific reasons.
It really paints a picture of litigation not just being one straight line, but having all these potential turning points and checks along the way.
Definitely. These motions are the procedural mechanisms for ensuring cases are decided correctly, both on the law and the facts, and for correcting errors when they happen. Understanding them, as Angela's notes help us do, is key to understanding how the system functions.
So as you think about this, maybe consider, when would a party choose one type of motion over another? Think about summary judgment versus going to trial, or RJ Mole versus just asking for a new trial. What strategic calculations might be involved, especially considering those strict deadlines Angela highlights?
Good question to ponder. The choice often depends on the specific facts, the perceived strength of the evidence, and frankly, the tolerance for risk and expense.
Lots to think about there. Thanks for taking this deep dive into these crucial federal procedure motions with us.
Thank you. It was a good discussion.
Hey, this is Angela. I am back. Anyhow, so yeah, that was a discussion on motions. I have to say, though, so I worked as a judicial law clerk for over a year, about a year and a half. And the whole time I was a clerk, I never did a single JMOL, which is weird because as much as the bar exam tests it, you would think that they would be happening all the time. But I literally never dealt with a single one, which was bizarre. But I did do summary judgments quite a bit. So summary judgments, I think, are they take a while to process. I think they're probably more fun to write if you're a defendant or plaintiff rather than being a law clerk, because there's just so much to go through. In any case, thank you for tuning in. So the next topic on civil procedure we have coming up is on verdicts and judgments. So yeah, another interesting one. I always like working on doing the final judgments when working as a law clerk. If you need to reach me, I am at podcast@studyforthebarinyourcar.com. And if you need to reach me to do any legal work, so if you are an attorney or you know an attorney who needs additional help or a law clerk to do some work, they can reach me on hello@legalwriterandlawclerk.com. Thanks for listening, and we'll see you on the next episode.